This raises jurisprudential question as to whether the Commission is seized of judicial powers, since it could investigate and determine complaints. It is therefore tried that judicial powers are vested in courts and other tribunals in Nigeria only by virtue of the provision of Section 6 of the Constitution of the Federal Republic of Nigeria. It will also amount to travesty of justice if the investigating body determines the complaints and makes same enforceable, as it is a principle of justice, and no man shall be a judge in his own cause. The lawyers here no nemo judex in causa sua. It is also against the letters and spirit of Section 36(1) and 4 of the Constitution of the Federal Republic of Nigeria, which guarantees right to fair hearing before an impartial tribunal or body. It is worthy of note that in the armed forces of Nigeria, for example, by virtue of the provisions of Section 134(2) of the Armed Forces Act, Chapter 820, an officer who is the commanding officer of an accused person or investigated the case shall not sit as a member of a court martial.
You can agree with me. Look at surprises like the NSAS protest. There was no, as I'm telling you now, the Special Investigation Panel, which the Human Rights Commission instituted to deal with NSAS protest, has not yet been funded up to now. Now, could we have made provision for the NSAS protest in the budget of that year? Human rights, look at the security situation in the country. These things are rising every day. If government of Nigeria really wants us to be effective, the issue of this human rights fund should not even be negotiable, because, you know, all the companies were asking to make contributions. Are they not supposed to benefit from a peaceful climate to conduct their business and make profit? It cannot be government alone that should fund a peaceful environment, which human rights adjudication, determination of violations will help this country. A lot of the problems we're having in insecurity are as a result of human rights violations that have not been attended to in the past.
The Commission should be encouraged or should be directed to synergize with the institutions that may be operating those laws. Because some of these institutions have peculiarities that their laws set out to address. And I must confess that for those of us in the armed forces, for instance, we have the Armed Forces Act. Now, for an average civilian, if he looks at the act, he might feel some of those provisions will trample on people's rights. But for us in the military, there are a lot of things that we've been doing to ensure that we don't breach the rights of not just civilians, but even our own personnel. So what I'm just saying in essence is that in the exercise of those powers, the Commission should please be encouraged to always discuss with the institution that is operating those laws before they go into either calling for its complete repeal or even amendments.
We looked at the conflict between the Human Rights Act and the Freedom of Information Act. Precisely Section 6, sub 4, paragraph A, which provides that it's an offense for anyone to refuse to provide evidence, including documentary evidence, to note that the proposed provision is inconsistent with the provision of freedom of information. That's to permit the denial of an application for any information, disclosure of which may be injurious to the defense of the Federal Republic of Nigeria, or disclose the identity of a confidential source as well as information which could compromise the security of the nation. Thus, the proposed Section 6, sub 4, paragraph A of the Human Rights Act could be amended by adding the clause, except where such disclosure is not permitted by law or court order.